Welcome back to the Indian Patent Agent Examination Preparation video series by Patwise Consulting Solutions. Today's session is about the Indian Patent Act 1970, Chapter 2. This chapter talks about inventions that are not patentable. The definition of inventions non-patentable is the Act does not endorse these as not inventions. They do endorse this as inventions, but however, the legislation intent is that these inventions are not patentable, which means an exclusive monopoly is not granted to the inventors of these inventions. The Section 3 and Section 4 details about what are the inventions that are not patentable. Section 3. What are not inventions according to the Indian Patent Act 1970? An invention which is frivolous or which claims anything obviously contrary to the well-established natural laws. So anything which has already been proven to be a natural law, and if you are inventing something which is contrary to the established natural law, then these are frivolous by nature and these are not patentable. Section 3b. An invention, the primary or intended use or commercial exploitation of which could be contrary to public order or morality, or which can cause serious prejudice to human, animal or plant life or health or to the environment. So even if an individual invents a new subject matter which is against morality, or if it is causing any harm to plants or animals or human, then those inventions are not patentable. Section 3c. The mere discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substances occurring in nature. If a person invents a new theorem or a new principle, a scientific principle, and this abstract theory or scientific principle or a theorem alone without its application is not patentable. Section 3d. The mere discovery of a new form of a known substance which does not result in the enhancement of the known efficacy of that substance, or the mere discovery of a new property or a new use of a known substance, or of the mere use of a known process, machine or apparatus, unless such known process result in a new product or employs at least one new reactant. This is a very important clause in the Indian Patent Act, wherein Section 3d simply says that slight non-incremental inventions are not patentable. If already a known form of a substance, say for example if a D form of a substance is already patented, then an L form or the lever form of the same substance is not patentable until it shows an enhancement of efficacy. Now for the explanation, the Act itself says, for the purpose of this clause, salt, esters, ethers, polymorphs, metabolites, pure form, particle size, isomers, mixtures of isomers, complexes, combinations and other derivatives of known substance shall be considered to be the same substance itself, unless they differ significantly in properties with regard to efficacy. Next, Section 3e. A substance obtained by a mere admixture resulting only in the aggregation of the properties of the components thereof or a process of producing such substances. In explanation to Section 3e, if substance A and substance B separately have properties C and D, just by mixing A and B, if the together substance A plus B is also giving the same properties C and D, which means they are just admixtures, they are not interacting in any way to have a new property or creating a new substance. So any substance obtained by just mere admixture alone, which results in the aggregation of the properties, is not patentable under Section 3e. Section 3f. The mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a no way. The explanation of 3f is the same as that of 3e, wherein if a particular device has two components A and B, and component A has a function C and component B has a function D, then just because of rearrangement of the components, the same function is provided, then the rearrangement or arrangement of that particular component does not result in a new invention. Hence, these inventions are not patentable under section 3F. 3G is omitted. 3H, a method of agriculture or horticulture is not patented. 3I, any process for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic or other treatment of human beings, or any process for a similar treatment of animals to render them free of disease or to increase their economic value or that of their products. According to section 3I, a treatment method invented by a doctor or a surgical method invented by a doctor is not patentable. Section 3J. Plants and animals in whole or any part thereof other than microorganisms but including seeds, varieties, species and essentially biological processes for production or propagation of plants and animals. We all know that plant varieties are also being protected under a different act. Hence, plants and animals except for microorganisms are not patentable according to section 3J. 3K, a mathematical or business method or a computer program per se or algorithms are not patentable. Hence, computer softwares, the source codes are not patentable under the Indian Patent Act. Per se can be interpreted as if there is a software which has an application, then the application along with the software can be patented. However, source codes alone are not patentable under the Indian Patent Act. Section 3L. A literary, dramatic, musical or artistic work or any other aesthetic creation whatsoever including cinematographic works and television productions are not patentable under section 3L. These are protected under the Copyrights Act. 3M. A mere scheme or rule or method of performing a mental act or a method of playing a game are not patentable. 3N. A presentation of information is not patentable, which is also protected under the Copyrights Act. 3O. Topography of integrated circuits are not patentable under Indian Patent Act. Integrated circuits are protected by a separate act. 3P. An invention which in effect is traditional knowledge or which is an aggregation or duplication of known properties of traditionally known components is not patented. Now, section 4. Section 4 relates invention relating to atomic energy not patentable. No patent shall be granted in respect of an invention relating to atomic energy falling within the subsection 1 of section 20 of the Atomic Energy Act. Hence, according to this chapter and according to this section 3 and 4, these are the inventions which are not patentable. Let us now look at a few cases applicable to section 3 of the Indian Patent Act. Case 1. Gravity wheel, a perpetual motion machine. The invention claimed a powder delivery wheel which is in perpetual motion. The applicant claimed that the claimed device to never stop until human intervention. It was also claimed that the machine was an engine of the unlimited size and capable of continuous power output from gravity force, and a gravity force can be universally available in any planet. The examiner's decision to the application was that any machine that gives more than 100% performance, a perpetual motion machine of the first generation which claimed to produce work without energy, is contrary to the law of thermodynamics. Hence, the patent was abandoned under section 21(1) on the ground of section 3A as its performance was contrary to the law of thermodynamics. Case 2. This deals with section 3B. There are two cases in this sections. One is related to oncomouse. The oncomouse is genetically modified to develop cancer for the purpose of medical research was not patentable because cancer could be transmitted to the public. However, based on ground of morality and reproducibility, the patent applications on animal models are not granted. Another application filed by Standard Innovation Corporation titled Electromechanical Sexual Simulation Device. This patent deals with sexual simulating vibrator and its intended use or commercial exploitation was in contrary to public order or morality. Hence, the patent was rejected based on section 3B. Case 3. Gene family associated with pancreatic cancer. The invention relates generally to the changes in gene expression in human pancreatic adenocarcinoma, a human gene family which is differentially expressed in cancerous pancreatic tissues compared to the corresponding non-cancerous pancreatic tissues. The applicant filed for the 777 base pair and the prior art, which is the native non-cancer pancreatic tissue, had 764 base pairs. The claim sequence ID having extra 13 base pairs, but the applicant does not show any advantages due to these extra 13 nucleotide base pairs. Further, the invention claims the production of polyclonal antibodies, which is directed to a host cell. The decision of the controller. Production of polyclonal antibody is directed to a host cell, which is not allowable under Section 3J of the Act. The isolated nucleic acid or the polypeptide sequence from human genomic DNA, which is considered to be an isolated non-living substance occurring in nature, is not allowable to be patented under the provisions of Section 3C of the Act in absence of any clear recombination in these molecules. Case 4. Sterile pharmaceutical composition. This invention, filed by American Biosciences, titled Sterile Pharmaceutical Composition, was a PCT national phase application. The claim 1 includes a sterile pharmaceutical composition including a water-insoluble anti-cancer agent and a pharmaceutically acceptable carrier albumin. Claim 2, dependent on the independent claim 1, the ratio of albumin to the anti-cancer agent was 1:1 to 9:1 and the size of particle was less than 200 nanometers. The decision of the controller. After the hearings, the patent was refused on the ground of Section 21J, Section 3D, wherein the Section 3D talks about the mere discovery of a new form of an old substance or a new use of an already existing substance or process, and Section 3E, which talks about the mere admixture without any improvement of the Patent Act 1970. The specification were also insufficient, so the rejection was also on the grounds of Section 10 of the Patent Act 1970. Case 5. Gel useful for the delivery of ophthalmic drugs. The claims were aimed at a solid powder comprising a mixture of A. Carboxyvinyl polymer as a gelling agent, B. A buffer, C. A saccharide or sugar, D. One or more drug used for the treatment of disease of the eye. Now the decision of the controller. The controller in his verdict stated that the composition of this ophthalmic preparation, a solid powder of the claimed invention, was not novel since all the ingredients were unveiled in the prior art, which is cited in the examination report. Hence, the product did not meet the criteria as a new product of the Indian Patent Act. Further, the inventive step is missing in the drug delivery system claimed as no therapeutic efficacy was exhibited. Creating a drug delivery system, powder or gel of different well-known components and verifying release rate of drug, that is the amount of drug released after 30 minutes to 6 hours, are regular experimentation carried out by medicinal chemists or trained artisans. The rejection was on the basis of Section 21J. A mere showing enhancement in bioavailability and retention time of the drug system was not adequate to evade the requirements of Section 3D, and data indicative of therapeutic efficiency was needed for the product. In absence of such data, the drug delivery system as claimed was precluded under Section 3D. Case 6. Process for the production of recombinant proteins using carnivorous plants. The applicant claimed that carnivorous plant can be used as a medium for the production of protein of interest. The applicant claimed a process in which plant was genetically modified by transformation and protein was expressed in the digestive secretion of the genetically modified plant. The decision. The patent application was refuted under Section 15 based on grounds of Section 3J. Further, cultivation of plant, growing of the plant, harvesting of fluid from the trap was considered as a method of agriculture. Hence, it was also not patentable invention as per Section 3H. Case 7. Method for hybrid gastrojejunostomy. The claimed invention talked about a method for joining one piece of tissue to another piece of tissue. The decision from the controller. A method of joining tissue, which is a surgical method. The subject matter is excluded from patentability according to Section 3I of the prevailing Act. Case 8. Chaos theoretical exponent value calculation system. The inventor discusses a system which can analyze using a method based on chaos theory and calculation of a chaos theoretical exponent value. The conventional system, which is in the prior art, was not calculating the temporary changing dynamics as a significant value. Hence, the inventor overcomes the disadvantage of the prior art, wherein the present system can process at a high speed on a real-time basis to calculate the chaos theoretical exponent value even from a time series signal which includes noises. The decision of the controller that the invention was not found to be patentable on the grounds of Section 3K of the Indian Patent Act, wherein Section 3K relates to a mathematical business method or a computer program per se. Case 9. Beta crystalline form of the imatinib missile salt, the Gleevec case. This is one of the landmark cases in the Indian patent history. In January 2006, the patent controller in Chennai refused to grant Novartis, a pharmaceutical company, a patent agreeing with the contentions of the CPAA and generic manufacturers that it lacked novelty, was obvious and was not patentable under Section 3D. That it was only a modified version of an existing drug imatinib. Hence, the drug imatinib missile salt is only a new form of a known substance. Novartis had not filed in India the precursor, that is the imatinib drug, as India did not allow the granting of product patents of drug prior to 2005. Novartis developed the beta crystalline form of imatinib, imatinib mesylate, which is found to have 30% more bioavailability than its non-salt form. That is, absorb 30% more easily into the bloodstream. They contended the term efficiency in section 3D is vague and not clear. Moreover, enhancement of efficacy and significant enhancement of efficacy was also not clear. The timeline of the case, wherein 1993 Novartis files patent worldwide for the active ingredient of Gleevec, imatinib, but not in India. In December 1994, India signs the TRIPS agreement, according to which India should now grant product patents for food and pharmaceuticals. In 1997, Novartis begins to file patents for the second version of the drug imatinib mesylate received under the mailbox provisions in India. In 2001, Gleevec imatinib mesyl sulfate was granted in the US. 2003, Novartis granted preliminary exclusive right, the EMR, according to the new provisions of the Indian Patent Act. In 2005, India officially changes its patent laws and started looking at new and mailboxed patent applications, including for the Gleevec drug. In January 2006, India rejects Novartis patent application for Gleevec under Section 3D of the Indian Patent Act. While in May 2006, Novartis files two legal challenges against Indian decision. August of 2007, the Madras High Court rules against the Novartis attempt to overturn Section 3D. Whereas in 2009, the IPA board rejects Novartis appeal. Novartis files a new court with the Supreme Court of India. The controller argued that Gleevec should be rejected because the modified version of the drug did not exemplify a significant change in therapeutic effectiveness over its previous form. It further stated that the selection of a salt of an active ingredient with the purpose of improving bioavailability, also referred to as evergreening, is a well-known pharmaceutical art. India's patent laws contain certain provisions such as Section 3D which ban this sort of practice in order to protect access to medicines for its population. After hearing both the arguments, the decision of the Supreme Court of India was the therapeutic efficacy needs to be enhanced in order for an adapted compound to be considered to fall outside of the 3D exclusion. The requirement of efficacy as stated in 3D should be therapeutic efficacy and not merely physical efficacy. Hence, the drug Gleevec was not granted the patent. With this, we come to the end of session 4 of the Indian Patent Act relating to inventions not patentable. Thank you for listening in. Please drop in your comments and feedback in the comment box. Subscribe to be a part of the upcoming series.